Well, thank you very much, Joseph, for your welcome, your introduction, and thank you to Norman for the invitation to come and speak to you this afternoon. On this apparently simple question, does English law need marriage? And I stress there the term English law. I'm not interested in the social or economic or emotional arguments for why marriage, the marriage state, might be a good thing or not. I'm interested only in the question of whether there should be a legal category of married and whether the law should attach rights and duties to that distinctive status of marriage. And you might think that's a slightly strange question to ask, and in one sense it is a slightly strange question to ask, but here's why. We get this clicker to work. Yes, we're there. Well, is it worth asking this question, does English law need marriage? Well, the first point to make is, of course, the steady rise in cohabitation. In the 1980s, when I started being a student, only 30% of young people lived together before getting married. Is that working? Thank you. 30%. The figure is now 80% of young people live together before getting married. The proportion then that eventually do end up getting married has dropped from about 2/3 in the 1980s to about a half today. An increasing proportion are separating instead. So on the one hand, we have this increasing indifference on the part of the population as a whole to the status of marriage. The second point is that marriage, as we know, is increasingly contested morally. It's contested morally by those sexual minorities who wish to use marriage as a high-value symbol in campaigns for social legitimation. So there is obviously pressure to redefine marriage in such a way that those currently excluded or in the past excluded from that state can be included within it. There is a particular point of tension as a result of the same-sex marriage legislation for the Church of England. Those of you who care about this, Henry VIII back in 1533 enacted a wonderful piece of legislation called the Submission of the Clergy Act, which has in its section 3 a provision that says that the canons of the Church of England shall not be incompatible or repugnant to the law of the country. Now, of course, when the same-sex marriage legislation was passed, an exception making sure that Section 3 of the Submission of the Clergy Act 1533 didn't apply was put into the legislation. But it doesn't deny the rather wider point that here we have an established church whose teaching, official teaching on the nature of marriage is at odds with that of the law of the country within which it is established. A slightly more technical problem, but one which exercises a number of people, is the way in which the current law excludes a number of groups from getting involved in the process of getting married. So some of you may have heard of the litigation that took place on behalf of the Scientology Church a couple of years ago in order to get their chapel registered as a place in which marriage ceremonies could be held. That was the case of Hodkin and the Registrar General. It went all the way up to the Supreme Court, who decided that the existing law was too narrow. Scientologists, in principle, ought to qualify for the conduct of marriages. And of course, then you can raise the question about a range of other groups who might or might not be included within the legal definitions. So if, for example, you want to conduct a pagan hand-fasting ceremony in the woods somewhere in the middle of Wales, can you use that as a way of celebrating a legally binding marriage? Answer, no, but why not? So we have a number of points of difficulty around marriage, ranging from these enormous social changes that we are witnessing around us through to some slightly more technical problems about who can get married and how under English law. Having said that, I do have to reassure you there is no prospect of major reform in the near future. The Law Commission recently carried out what they call a scoping exercise, a scoping paper at the invitation of the government around the process of getting married. And this is a one-line sentence of their conclusion. It is clear that the law governing how and where couples marry is in dire need of reform. That, I think, is entirely correct. But notice the restriction, the law governing how and where couples may marry, or couples marry. There is no question here of changing the legal status of marriage as such, or the legal definition of marriage, now that it's been changed after the same-sex couples legislation. There is no question of fundamental, radical, or major reform to the law of marriage. There is a question about process, about ceremonies, how and where couples marry. So is it worth asking the question, in one sense, as a matter of pure practical politics, no, we don't need to ask this question right today because the government is not thinking of abolishing the status of marriage or removing the legal status of marriage. But it is, I think, still worth asking it because of the pressures we are under, and because also, as we'll see in a moment, a number of academic scholars, an increasing number, are proposing that the law should get out of marriage. And it's worth asking whether they are right, and that might help us see our way more clearly to why we have a marriage law in the first place. So let's look at some of those arguments for de-legalising marriage. There are, I think, three groups of argument in the academic literature suggesting that marriage should cease to be a legal category or a legal concept. Firstly, we have what we call libertarian arguments, arguments from freedom or liberty. So the argument on the part of some of these people is that marriage represents a particular package of assumptions around how people should live together. And it is not clear that the law should impose one single package on the population at large. Rather, as individuals, we should be free to design our own relationships as we choose. There should be more liberty. And the way we would then enter into marriage under a libertarian argument is by way of contract. Just as you can enter into a contract for the lease of a flat for a year or for a very, very long time or for only a month, so you should be able to contract with a partner how long you intend to stay together. Is it to be just a short-term relationship, or is it to be a much longer-term relationship? Just as in a contract you could put in an arbitration clause saying that in case of dispute, your dispute will be arbitrated by some trusted third party, so in a marriage contract you could put in an arbitration clause saying that in case of dispute it will be resolved by, for example, a religious tribunal who could then rule on the rights and duties of your marriage from a particular religious perspective. So we have a set of arguments that suggests that we can design our own relationships and agree among ourselves how we are to relate, and they can be short-term or long-term relationships. They can be relationships that have a religious dimension or not, as the case may be. So that's one set of arguments for de-legalising marriage. We turn it into a matter of contract, of freedom of choice between two, or possibly even more, two or more parties. That's one group of arguments. We have a second group of arguments, which in one sense are the oldest arguments associated with feminist writers and more egalitarian, equality-minded writers, who argue generally against the institution of marriage as a patriarchal and oppressive institution. So we think of writers from Simone de Beauvoir onwards, who argue that marriage is a way of men owning women and treating women more or less like property, and the law of marriage contains echoes of that and reinforces that sort of patriarchal assumption. And the only way of dealing with that sort of oppressive inequality, the oppression of men over women, is to remove the legal framework. And then thirdly, we have, and this is perhaps not so common, but it is growing, a group of Christian arguments. So Christian theorists who say that marriage is first and foremost a relationship which is conducted in the sight of God and in the sight of the church, and that for the state to define what a marriage is an inappropriate form of entanglement between the state and religion. We believe that the church should be free from state control, and in the same way that the church should be free from state control, so also should marriage be free from state control, because it is a sacrament or a religious ceremony. And there's actually a very interesting parallel to be observed between the process of religious liberty since the 17th century in this and other similar countries and the process of reform, marriage law reform. So if we go back to the 17th century, we find that the first stage in religious liberty is a growing toleration of religious minorities. They don't have the same legal status. In fact, they hardly exist at all as a matter of law, but we allow them to survive. We don't persecute them out of existence. And then after a while, particularly in the 19th century, you get the idea that religions should be equally recognized. So the what we used to call nonconformist Christian religions and Roman Catholics get access to the same legal status as the Church of England enjoyed in this country. And then the final stage, this takes place in the late 19th and 20th century, not totally, we have an established church, but mostly you get separation. And of course you get that in the United States, big time, where the church is over here and religion is over there, and the state is over there. Now, if you think about it, if you look at the history of marriage change, we see a similar sort of process where unconventional relationships or the relationships of sexual minorities are first of all tolerated, so we remove criminal sanctions. It's no longer a crime to have same-sex relations, for example. And then toleration gives way to equal recognition, and that, if you like, is the phase we're in at the moment. And the logical consequence is to go to the third and final step and separate marriage from the state altogether. So we have a group of arguments coming from very different political backgrounds, philosophical backgrounds, all suggesting that we should de-legalize marriage. What I want to do in the next part of the talk is just to sketch in for you some historic trends in English marriage law. It's quite interesting when we look at the way the law has developed. I think we can see elements of all those three arguments that I just outlined for you. So we can see there is a sense in which marriage law has become a bit more contractual, a bit freer. We are more free now to design our relationships than we were, say, 20 years ago. There's an element of the equality argument being brought in. Certain of the more obvious patriarchal elements of Old English marriage law have been removed. And there is even a sense in which, to some extent, marriage has been separated away from the state interest. So each of those three groups of argument have a little bit of resonance with the history. The history of English marriage law is really one of the gradual removal of historic common law consequences of marriage. And I'll take you through the most significant ones of those in a few moments. So the common law, before statutory intervention, had a certain view of what the legal consequences of marriage were, quite robust and remarkable view in a modern perspective, and they have been removed over time. At the same time, from about the 1930s onwards, very slow in the 1930s, increasingly after the Second World War, legal consequences have been created for cohabitation instead. And this is important because, of course, cohabitation is the main functional equivalent of marriage for an increasing number of couples today. So we see the removal of the historic common law consequences of marriage. We see the gradual creation of legal consequences for cohabitation instead. But there are still a few significant differences between the two. And those are the ones which we need to focus on if we're thinking about the relationship between marriage and cohabitation. So let's start with those historic consequences of marriage in the English common law. There were two key doctrines which informed the Old English common law of marriage, and they were called the doctrines of spousal unity and consortium. The doctrine of spousal unity is the doctrine that husband and wife are one, and in law the husband is that one. A slightly cynical comment, but actually not an inaccurate one. So on marrying, the wife's personality became submerged in that of her husband. Her property became his property, and he represented the family unit for the purposes of the outside world. The doctrine of spousal unity. We have a few echoes of spousal unity. Most of it has gone. It went in the late 19th century, but there are a few echoes left of spousal unity. For example, two people who plot together to commit a criminal offence can be charged with conspiracy. Conspiracy to commit a whole range of offences, but not if you are a husband and wife. Husband and wife plotting together cannot be found guilty of conspiracy. Two cohabitees could be. Here's another example of spousal unity, and there's a recent case on this in which two cohabitees were found guilty of conspiracy. Here's another example. In the case of civil actions, tortious actions, where you're suing for damages, it used to be the case that you couldn't sue a wife, or a wife could not sue unless she joined her husband as a party. They had to sue together, as it were, as a team. That's an echo of spousal unity. But now it's the case that there are protections for the husband and the wife such that they cannot sue each other. They're not allowed to sue each other unless the judge gives permission for that to take place. And again, that's slightly unusual. It's a reflection of spousal unity. And there are a few other minor examples as well of spousal unity. It's still the case that you can only compel a wife or a husband to give evidence against the other in a criminal trial in certain limited cases, cases of sexual abuse within the family typically, whereas there's no restriction on forcing, under subpoena, forcing cohabitees to give evidence against each other. Again, these little echoes of spousal unity, but for the most part it's gone. What about the doctrine of consortium? Well, the doctrine of consortium was the doctrine that you have a right to each other. You have a right to share each other's bed and board, as it was sometimes called, and this could be compelled or enforced in various ways. So a husband could force his wife to return to the matrimonial home by law. Again, that's largely been abolished. We tend to think that marital relations should not be subjected to legal coercion in that way. But there is an echo. There's an echo in the fact we still have a legal power of separation. You can apply for an order of judicial separation. You don't need to do that if you're a cohabitee. You can just leave. In fact, you can just leave as a married party in a relationship as well, but for some reason we still keep this judicial order of separation. It's actually a reflection of the old doctrine of consortium. Desertion is still a fact which evidences irretrievable breakdown and thus potentially divorce under English marriage law. Why is desertion an offence under marriage law? It reflects this idea that you should be together. So that's another doctrine that's kind of largely been removed. Permanence, we'll all know this one. Historically, of course, it was very difficult to dissolve a marriage. It required an Act of Parliament, which was very expensive and time-consuming. And apart from that, you couldn't get divorced. And of course, over the years, divorce has become much more available, such that it's hard to say that marriage is necessarily a permanent relationship. Perhaps permanent in intention, but not really legally. And as I said, there are minor residues of these three doctrines of spousal unity, consortium, and permanence within many branches of the law. Compare that with the change that has happened in the law on cohabitation. So in a whole range of areas, the law has come to treat cohabiting couples in exactly the same way as it treats married couples. And those are some of the principal ways listed there on the screen. So we have identical approaches to domestic property. If, for example, one of a married couple goes bankrupt, perhaps typically the husband, and the question arises, how many assets are available to satisfy the creditors? What falls into bankruptcy proceedings or not? Clearly, there's going to be a question about which property belongs solely to the wife and therefore does not fall into bankruptcy proceedings, and which property belongs jointly to both. Now, the law approaches this question of the ownership of marital property in exactly the same way, whether you are married or whether you are cohabiting. It's still in principle based on the financial contributions that each party makes. The law is actually rather complicated. We won't go into the details. Second similarity is that domestic contracts entered into between cohabiting couples or between husbands and wives are generally unenforceable. Again, there are a few minor exceptions, but the law is the same whether you cohabit or are married. By contrast, the phenomenon of the prenuptial agreement, the prenup, is growing in its legal acceptability. The Supreme Court fairly recently ruled on this issue and held that in principle a prenuptial agreement between spouses could be enforced so long as it was a reasonable preparation for the possibility of separation later on. The case involves a very wealthy couple, extremely wealthy couple, because of course they could afford lawyers, and the couple split apart, and the man, who had earned a handsome salary, became a student and wanted to claim maintenance from his former wife. Unfortunately, there was a prenuptial agreement that said that if they were to split, they would basically each keep their own property, and the question was whether she could rely on that prenuptial agreement or not. The point is, it doesn't really make any difference to the Supreme Court whether you're married or cohabiting. In both cases, prenuptial agreements are, with some conditions attached, enforceable. There is legal provision for your family and your dependents on your death. If you fail in your will to make adequate provision for somebody who is dependent on you, or if you die intestate and there is a question of their financial resources, again, since the 1970s, the law has given cohabitees a right to claim as much as a former spouse could claim under that law. Compensation for wrongful death. If your partner is killed in a road traffic accident, for example, you can claim as either cohabitee or as spouse compensation. The rules conferring the transfer of tenancy on death. Suppose one of a party is the tenant of a house or a flat, the other is not party to the tenancy agreement, and the one who is the tenant, technically in law, dies first. Suddenly you're left with a situation where the remaining party has no legal relationship with the landlord, and they could in principle be thrown out. The law prevents that by setting up a scheme whereby you can inherit the tenancy automatically as a matter of law, and the rules there are exactly the same, whether you're cohabiting or whether you're married. Remedies for domestic violence. Not surprisingly, they're the same. Domestic violence is as much a social problem among cohabitees, among married couples, so you have to have the same provision there. Social security benefits. This was one of the first ones, not surprisingly. Also, the government is not going to ignore the fact that you are sharing accommodation with someone when calculating the benefits that are going to be paid out to you under social security, and likewise with immigration requirements as well. The law treats cohabitees in the same way as married couples. So we can see on the first hand that the law over time has removed those very distinctive features of the common law of marriage, whereby the couple were treated as a single unity and had duties and rights to share in each other's lives. That's been largely whittled away, and instead the law over the course of the 20th century has created more and more consequences for cohabitation. So what are the differences that are left? Well, here we go. The main one, and the most problematic of all, is the power to redistribute property and give financial provision on nullity, separation, and divorce. So when a marriage breaks down, the court, the judge, has a considerable discretion to work out who gets what. And that means that they can make provision for a party who would otherwise be destitute or poor, and can make sure there's appropriate provision for the support of children as well, depending on who's looking after the children, if there are any. Those powers simply do not exist in the case of cohabitants, couples who have lived together, even if they've lived together for 20 or 30 years. So you can imagine a situation in which a couple move in together, the man becomes the main breadwinner, pays the mortgage, perhaps the house is in his name, and then they split up and the woman has absolutely nothing and no legal remedies. That's the main problem with cohabitation. Second biggest problem is in this area of wills and intestate succession, particularly intestate succession, dying without making a will. When you get married, it automatically invalidates any will that exists. And of course, the law then cuts in and presumes that you would want to leave your property to your spouse. So marriage has an enormous impact on the law of succession. But cohabitation doesn't. It's quite hard to see how it could as well. So if you move in with somebody while you are still married, so imagine a man has a relationship, he's married, and then moves out, they split up, but without getting divorced, he then moves in with another woman, then under the law of intestacy, it's the wife, the former relationship, who would inherit, and the cohabitant could only make a claim if she was financially dependent, a claim on the estate. So that's a big and important difference between the two. Thirdly, this issue of recognition of paternity. Because I and my wife were married when my daughters were born, the law automatically assumed, I think with good reason, that I was their father. In the case of cohabitants, the law cannot assume that. It does not know who to assume is the father. So you have to get paternity rights as a father in a cohabiting relationship by registration or by court order. And interestingly, the law presupposes that you could, if necessary, show the genetic relationship. If you were put to it, you could ask to be proved, have that genetic relationship proved, and if you are not shown to be the genetic father, then you cannot register as the father in a cohabiting relationship. Interestingly, the court even has a discretion even if you are the genetic father. So there's an interesting case where a same-sex couple, two women, had a child, one of them had a child, by a man who was known, so we say informal artificial insemination, who was known, and who was also in a same-sex relationship of his own. So we have a female-female couple and a male-male couple. And after the child was born, the genetic father made an application for paternity rights to be recognised as the father. And the court refused on the grounds that it would completely destroy the arrangements between the two parallel sets of couples. Fourth difference, home rights. This is a little area in which for protection, really in the case of domestic violence, if you are married, you have a right to occupy the family home, a legal right, whatever the precise legal relationship is. So if the husband is the sole owner of the matrimonial home, the wife, by virtue of being married, has a right to occupy that home. More realistically, if the husband is the tenant, the wife has a right against the landlord to occupy the home. Not if you're a cohabitee, and the law has to make sort of adjustments for that to recognise the situation where, for example, you have a violent man who is cohabiting with a woman who's looking after children, and the question is who gets to stay in the flat? Does the man get chucked out, or does the woman get chucked out with the children? And the man is the tenant, the woman is not. Well, the law will intervene at that point and give the woman certain protections to keep her in the flat and make sure that it's the man, although he is technically the tenant, that he's the one who gets chucked out. So there's a slight difference in the way the law handles home rights, as we call it. And finally, joint taxation. Joint taxation hardly happens in this country. Probably know it happens a very little bit. It's really minimal, but it is one difference between cohabitation and marriage. Well, we might look at that. We might look at the fact that cohabitation has become increasingly a legal alternative to marriage, and that the law has had to recognise that by transferring what used to be the legal consequences for marriage into cohabitation, and say, well, why don't we then do without marriage altogether? Why don't we just complete the process? And that would be called creating a purely functional definition of marriage. Because this is what cohabitation is. It's a functional equivalent. And the law defines cohabitation in a way that tries to attach to the social reality that is marriage-like. So why don't we just get rid of this formal status and say, as the cohabitation bill does, any two people who live together as a couple for at least 3 years, or as parents of the same minor child, and they're not already married or in a civil partnership, and they're not within prohibited degrees of relationship, are cohabitees. A legal technical term meaning that you switch on all those remaining incidents of marriage that currently don't apply. So the situation, as we've just seen, is there are legal consequences of marriage which are not shared with cohabitation. That creates injustice. It creates a problem, particularly around when the relationship breaks up. So why don't we then create a similar protection for cohabitation? We define cohabitation in this way, and anyone who falls into that functional equivalent then gets the same legal consequences, the same legal package as a married couple. There have been cohabitation bills, private members' bills, before Parliament for a number of years now. They get put forward every year. There's quite a lot to be said for them, but they fail every year because the government does not back them. The government does not back them because it wants to be seen to be, quote, supporting marriage. We could discuss this in question time afterwards. What I want you to notice, though, is that even if we were to introduce a law of cohabitation like this, and we were to switch on all those remaining consequences of marriage, legal consequences of marriage for cohabitees, we would be left with a couple of problems. The first thing I want you to notice is this reference to prohibited degrees of relationship. So, there is nothing to stop a man moving in with his sister and behaving as if they were married. They commit no criminal offence, assuming they are both adult, and assuming that the age difference is not so very great between them. We'll assume it isn't. But basically, we could do as the Egyptians. Incest is possible, incestuous marriages. It could happen, and perhaps it does, who knows, to a very small extent. That is a functional equivalent to marriage. And yet it does not fall within this proposed legal definition of cohabitation, and nor does it fall within any of the legal definitions of cohabitation with which the law is replete. Why? Because we think it is a very, very bad idea for brothers and sisters to engage in sexual relationships. Not criminal, it's not criminal, they're adults, but we don't think it should be recognised at all. And that's true of a number of relationships, both, if you like, close relationships within the family. There are obviously detailed rules here. That means you could never move to a purely functional definition. If we agree with the eugenic argument, and we agree with the argument about protecting families from sexual abuse, inappropriate sexual relationships across the generations and so on, then we have to have some concept of prohibited degrees of relationship. And that means that we could never move to a purely functional definition of marriage. There's an element there in which people who look as if they're married can't be. The second problem we would have is that a purely functional definition means that you cannot marry immediately. There's something to be said for this, I think. The idea that you are to be treated as married if you behave as if you're married, but merely saying that you're going to be married is not enough. I think there's something to be said for that. But it is problematic, and here's why. Because you might have a couple who want to get married, and who obviously haven't satisfied this test. They haven't lived together yet for at least 3 years, and they don't have a child, but they want to get married immediately. Could the law stop them? Would it be right for the law to stop them? Imagine a couple who go through a religious ceremony, for example, of marriage, and want to be treated as married. Would we say to them, no, you must wait for at least 3 years, or you must have a child before the law will treat you as being married or officially cohabiting? Human rights come into play here. Under Article 12 of the European Convention on Human Rights, which more or less repeats Article 16 of the Universal Declaration of Human Rights, everyone has a right to marry and found a family. So it would be very hard, I think, to argue that you should wait for 3 years before being treated as married. Let me quickly touch on one problem which I think we need to grapple with. And this is a real problem. This is not hypothetical arguments about whether we should or should not remove marriage as a legal status. This is a sector of our community that do not use the legal status of marriage, and that creates enormous difficulties. And they are British Muslims. We don't actually know how many British Muslims get married by an Islamic marriage which is not legally binding under English law. We don't know the proportion. The literature varies from about 30% of British Muslim marriages, potentially to as high as 80% of British Muslim marriages, are carried out typically in a flat, not in a mosque, by an imam in the presence of friends and family, and the man and the woman make mutual vows and they take each other as husband and wife. English law treats that as a non-marriage. Slightly funny word. It means it's something that looks like a marriage, but it isn't really. It's a non-marriage. A non-marriage means that you are cohabiting in the eyes of the law. Islamic marriage in our country is a key way in which first-generation immigration is refreshed. This is actually a problem. It's a problem because historically immigrant communities have over time approximated their lifestyle, their beliefs and practices to that of the majority. It's a natural process. But we're in a situation in which in each generation it's quite common to bring a husband or wife over from Bangladesh or Pakistan who then him or herself is obviously another first-generation immigrant. So you get this sense in which the British Muslim community is refreshed as a first-generation immigrant community, which of course reinforces difference and separation and exclusion. Furthermore, intercontinental marriages are under particular stress, particularly if a rural Bangladeshi or Pakistani man comes to this country and marries a girl who's been brought up in an English context. If you think about the mismatch of expectations that is likely to arise in that relationship, those marriages are under particular stress. So what we have is a large proportion of British Muslims entering non-marriages which are then under particular stress and which, not surprisingly, fall to pieces. That's even before we start talking about the prevalence of polygamy. There's been quite a lot in the press and even in Parliament about Sharia councils and how horrible they are and how patriarchal and awful they are, and we ought to get them under control. I don't share those criticisms of Sharia councils, as it happens. Sharia councils are undoubtedly not liberal egalitarian institutions, but their work is created by this phenomenon. The large majority of a Sharia council's work is derived from the breakdown of Islamic non-marriages. So you have women who cannot get a legal remedy because they're not married and their marriage is broken down, who go to a Sharia council trying to get what they can out of their now estranged non-husband in order to provide for some support for the family. So obviously in Islamic law there is a doctrine of dowry, of mahr, where the husband makes promises to the wife in order to support on the case of breakdown. Often those promises are not upheld. There might be a history of violence in the matrimonial home as well. And the Sharia councils that we know about are trying in their own way to provide some sort of a customary remedy to that problem. This is what happens when we have a sector of the population that does not get married, but does it, as it were, informally, under their own rules themselves. We see a considerable problem of injustice. What are we to do about that particular problem? Well, some of the proposals have been we should work very hard to register mosques. It's very interesting. If you look at nonconformist churches, about 80 to 90% of them are registered for the conduct of marriage. The proportion is the same for Jewish synagogues and for Sikh temples, but when you look at Muslim mosques, only about 20 to 30% are registered for the conduct of marriage. And everyone goes, well, that's the solution. We need to work hard to get our mosques registered for marriage. Muslims don't marry in mosques. That's not entirely true. Some of them do. It has been known. But the vast majority is just not part of their tradition. So we have a model in which marriage has to take place in a church or a registered building, which is a bit like a church, and it's one that doesn't fit the cultural assumptions of the British Muslim population. So we could try to register mosques, but I'm not sure that really would help us very much. The radical solution, and some people have suggested this, is revert to the common law definition of marriage. How did you get married under the old common law or canon law? We're talking before 1753. In the presence of witnesses, a man said to a woman, I take you as my wife, and the wife said, I take you as my husband, and Bob's your uncle. That's how you get married. That's how Muslims get married under traditional Muslim marriage. Why don't we just treat that as legally binding? Well, the government says, we don't want to do that because we're worried about sham marriages and we're worried about coercion in marriages and we want to have a register of who's married. We want to know. So that's not really a runner. We could develop the law of cohabitation. That would be a solution because we could then treat Muslim married couples as if they're cohabiting, and then we could give them legal remedies. But the government doesn't want to do that because that, quotes, undermines marriage. Does it? We could change the methods of civil registration. This is one that I think might make some progress. It's what the Law Commission has been working on. We should be able to have a system in which you can get married in your flat, in the presence of your family and friends, so long as the registrar has noted the name of the celebrant and there is a certificate that is filled in and returned to the registry office at the end of the process. Why do you need to get married on registered premises? Not obvious to me, and that's certainly an option that the Law Commission are looking at, and it might help to bring Muslim marriages within the scope of the law. What I don't think we should do is follow the libertarian, the egalitarian, feminist, and to some extent, Christian arguments, and effectively assimilate the law to the current Islamic position, because that is what's being proposed. It's being proposed that marriage should cease to be a legally regulated, legally recognized status, and instead become a purely social phenomenon governed by your own religious or social norms. That is what it is in the case of British Muslims, and it creates considerable injustice. So, I conclude that marriage is an inescapable regulatory challenge. We can't solve the problem simply by getting the law out of marriage. Why is that? That's something to do actually with the nature of law. Here we come to the fundamental theoretical bit. When legislators make law, when judges decide cases, as the law of a country unfolds, it never does so in a vacuum. The basic tension that law has to inhabit is a tension between a conception of justice and the realities of society. So law never simply follows what society does. There would be no point in having it if it did that. Nor, on the other hand, can law implement a pure vision of justice, some great ideal of how we would like everyone to live in an ideal world. It can't do that either. It would never work. Most law has to be followed by most people most of the time. So law inhabits this tension between a vision of justice, what good relationships look like, and in this case good family relationships, and where society is actually at the moment, wherever that happens to be. So if you're in a society in which polygamy is common, you do have to make legal provision for it somehow. Otherwise you will end up condoning or overlooking considerable injustice. There are social patterns of intimate domestic partnership that, sure, change over time, but actually heterosexual coupling is still incredibly common and incredibly normal and incredibly valued. We cannot redesign the law on a highly individualistic basis as if we're all separate individuals that go our own way, contracting with each other and destroying that assumption of the normal forms of partnership and relating. Another way of putting that is that the dysfunctional family, the negative side, is an essential object of law. When people commit to each other and then break their commitments, when children are at risk of getting hurt, when the vulnerable parties in a marriage are at risk of getting hurt, the law cannot simply stand by. It has to recognize the social reality that it's dealing with. And so we conclude that reasoned reflection on what the normative paradigm of marriage has to be as a matter of public right is inescapable. That's a slightly complex way of saying we cannot wash our hands of the issue and say marriage is a purely religious phenomenon or a purely personal phenomenon. There is a matter of public right at stake here. You could call that a matter of natural law, a matter of justice. De-legalization is not a realistic option or solution. Now we've got some time for questions and comment. If you're wondering what we could talk about or think about, here are 3 questions which I puzzle over and which you might like to puzzle over with me. Which elements of our current understanding of marriage are religious and which are social? I mean, what are those bits that are just inherited cultural contingencies from our Christian past and could be dispensed with, and which bits are, as it were, universal or normal, must be insisted on? What, if anything, should we do about the increase of cohabitation? Just ignore it? Or does the law need to change? And what, if anything, should we do about the Islamic non-marriage? Again, is that just a problem for them over there, or is that a problem for all of us that we need to think about? If you're interested in the arguments that I've been outlining for you over the last 40 minutes or so, a fuller version and a more detailed version has just been published in what's called the Tyndale Bulletin. It's a publication of Tyndale House in Cambridge under the title, Could Marriage Be Disestablished? The short version of that paper is a one-word answer, no. Thank you very much.